Welcome to Hot Chips 25. Keynote 3. Intellectual Property Issues in the Computer and Electronics Industries.
Okay, I'd like to introduce our third keynote speaker. Is Michael Brody, who's Vice Chair of the Intellectual Property Group at Winston and Strawn. Winston and Strawn is one of the larger law firms in the United States. He's coming here from Chicago. I should say Chicago. I think he lives on United Airlines. And he's going to be talking on the use and abuse of patents in the semiconductor industry. Mike is pretty well known in the field. He's given a number of talks. Mostly to legal conferences. I'm not sure if this is his first talk to a technical conference. And he's going to discuss a lot of topical materials, such as what's going on in litigation and why you find trolls under bridges. Mike?
Well, thank you, Alan, and thanks to the committee for inviting me, and thanks to all of you for willingly subjecting yourselves to an hour of conversation with a lawyer. That's not something we often find we can get voluntarily. I have to admit that much as I wanted to start my remarks with thanks, that really was not my initial reaction when Alan called me about this event. This is the first time I've spoken to a group of engineers on these topics. And my first reaction really was one of bafflement about why you would want to hear from a lawyer and how I would fill this time. And as I thought more about it, I think ultimately what I want to talk to you about is why I think that might actually make sense, because my industry, my profession has, which is primarily patent litigation, has undergone some genuine sea changes in the last decade or so. And it's had, I think, very direct financial and operational implications for your companies. And what I'd like to do is talk a little bit about what patents are and how they've been used traditionally, both sort of across industries and in the semiconductor industry, and then share with you a little bit about how that's changed really recently, and then we can talk about what that's meant for your companies and what we have to look forward to or to despair about, depending on your point of view, I suppose. So, what is a patent? Many of you probably have patents, so this may be coals to Newcastle, but it is the right place to start because it actually affects some of the things I'm going to be saying later on. The patent system is actually mandated by the Constitution. It's somewhat unique in that respect. Patents are a way of creating ownership rights in inventions. Inventions under the patent law are new, useful, and non-obvious ideas that relate to tangible things or ways of doing things. And I can speak for hours on each of those modifiers, but I won't. Basically, the ownership right that's associated with a patent is the right to exclude others from practicing the patented invention or to charge them for doing so. So the right's roughly analogous to the right you have in real estate. It's the right to keep somebody off of your property, to sue them for trespass, if you will, or to expect that they'll pay you a rent for using it. We live in a remarkable time for patenting. Over the course of the history of this country, we've gone through two major eras of great energy and depth and commitment and growth in patenting in this country. The first was in the Industrial Revolution between 1850 and 1875, and that's that, well, I won't try with this. That's that first red bar that you see, and the second is today. And really, it's a revolution that began in the mid-'80s and continues, if anything, at an accelerating pace as we speak. Much of that remarkable growth in the last 25 years has been driven by the semiconductor industry. This is the first of a number of slides that I'm going to caution you about because nobody knows what most of the terms I'm using actually mean. Semiconductor industry sometimes means literally the companies that primarily do this work. Sometimes it means anybody who has a patent that relates to computer chips. Different writers classify differently, and their counts end up being somewhat different. But I think you'll find that the trends are fairly consistent across most of these categorizations. As you can see, since the early 90s, patenting in the semiconductor industry has grown dramatically. It's roughly sextupled from a little between 10 and 20,000 a year. I'm sorry, about 15,000 a year to over 60,000 a year, 65,000. Semiconductor patents, at least according to this commentator, currently represent about 25% of all of the patents issued. So when you look at that alpine growth between 1985 and 2010, a lot of that is semiconductor innovation. Another key driver has been the software industry. This is a compilation that was done by the General Accounting Office recently, which has seen growth from about 25,000 patents a year to 125,000 patents a year. As I said, these numbers rapidly add up to more patents than there are, so there's a lot of double counting going on here. But the general trend, I think, is clear. The electronics industry writ large has driven a sea change in innovation and patenting. That's not news to anybody, but it is, at least in this context, quantifiable. As a consequence, again, not surprisingly, patenting has become a huge industry. According to the World Trade Office, the United States exported almost $90 billion with a B in licensing rights in 2009. That number continues to grow. That's about 5% of all U.S. exports during that period. And that, of course, doesn't include the domestic market. Now, this is all intellectual property licensing rights, so that includes Donald Duck and Goofy. But the bulk of it, primarily, we believe, is patenting. And patents are at least associated with let me put it this way. The activities that are associated with patenting are significant drivers of economic growth. This is a study that was done by the Brookings Institution. And roughly what they did was they isolated some of the different variables that are typically associated with growth in a market and regressed them in various ways and came up through the magic of statistics with the conclusion that about 3.5% of growth in GDP per worker growth is attributable or associated with the number of patent claims issued in a metropolitan area. So 3.5, in any given metropolitan area, roughly 3.5% of the growth that's experienced is, at least by this measure, associated with the activities that lead to patenting. That's a better, more significant driver than the number of bachelor's degrees in the market. It's larger than the amount of tech industry employment in the market. It's not quite as large as population or sector employment, but it's a major and a significant factor. This same study concluded that the average metro area in the bottom quartile of the areas surveyed grew by about 13% over this decade. If they had patented at the same rate as the metro areas in the top quartile, the growth by this measure would have been about 6.5% higher over the 10-year period. That represents an additional $4,300 a year productivity per worker, and obviously represents a 50% growth in what those areas would have experienced. So patenting is not only a robust activity, it is an economically massive one and a significant driver. And that's probably because it actually serves useful business purposes. These are from studies that have been done, various surveys that have been conducted within the technology industry and some others, asking people how they actually use patents. And generally the answer is to keep other people from doing what we do, which is essentially a way of saying patents are used in competition primarily as a way to define competition. They define the way in which companies go to market. They create product differentiators. They make it possible for a product to be marketed as something other than a commodity, to compete on a basis other than price, all of which drives, as I'm sure you can well understand, profitability and sales. These were surveys of larger firms. This is from a survey of smaller firms, startups. Again, you get the same sort of rationales. It's the way that we define ourselves is generally what you hear. It's the way that we succeed in the marketplace. And strikingly, it's not an activity that's really associated with a huge investment of time or money. In most economies, 3/4 of R&D expenditures are directed to development, not to research. It's much harder in terms of the amount of effort and capital that's committed and management time that's required and resources that need to be addressed to actually make as again, all of you well know, to actually make an idea into a product than it is to simply come up with an idea. But the patent really only relates to the idea itself. And the reason why the patent creates the sort of outsized value that it does at that very early stage of the innovation cycle is because of the nature of the legal rights that are associated with it. A patent's a monopoly, and as I suspect the executives in your companies would be happy to tell you, a monopoly is a nice thing to have. It makes a huge difference in the way, as I said, the way in which competition is conducted, and that's not surprising given what people have had to say about why they want to patent. It gives competitors a way of identifying, creating, and preserving points of differentiation, and it gives them a way of taxing competitors who want to compete directly in that space. But ultimately, it's really nothing more than a license to sue someone. Having a patent doesn't give you the right to go to market. It doesn't give you a successful product. It doesn't give you anything except the opportunity to, as I said, exclude others, which is, at the end of the day, and really at the start of the day, nothing more than a right to file a lawsuit. As a result, the value of all of the generator of all of that economic value that we were looking at in connection with patents is simply that right. It's the right to create these lawsuits, and it's driven by the sort of value that's associated with those lawsuits. So let's talk a little bit about what that kind of activity has looked like over time. This is from a study that was conducted of a sample of 136 semiconductor firms. The sample was kind of modified to take out some of the larger players so that the numbers wouldn't be swamped across the industry, and we'll look at some numbers for bigger players later on. This is the same numbers basically spread over time. And I don't think you can look at this without recognizing that there is a change over time. In the 70s, The amount of litigation in the sample was relatively modest. There were a total of 17 cases filed during that decade. Between 1983 and 94, 181 cases were filed. And between 1995 and 2001, so a 6-year period as compared to the prior 10-year period, 247 cases were filed, again, just for this sample. That translates into growth from about a little less than 2 cases a year in the 70s and early 80s to about 16 cases a year, 83 to 94, and 34 cases a year by the late 90s. Again, we're talking about the numbers for this sample. Other studies have recognized a similar trend. This is from a study that was done by a Jones Day lawyer. He concluded that during the period 1997 through 2007, so that's kind of adding on to the period that we were looking at, that trend of growth continued. By his count, there were 900 patent lawsuits filed involving the semiconductor industry during that period, an average of about 90 a year. And those numbers increased each year, doubling during the decade. This is from a study done by PricewaterhouseCoopers. They didn't separately categorize for semiconductors, but they did identify computer hardware and electronics companies, telecommunication companies. That's a superset that includes probably the most semiconductor litigation. Typically, or not typically, but in any event, often the lawsuits against device makers and network makers are addressing functionality that's built into a semiconductor. And here too, you see this doubling again. In computer hardware electronics, the number goes from 24 to 48 to 101 starting in 1995 through 2000 and ending in 2007 through 2012. Telecommunications, it's a very similar trend, 13, 27, and 50. So there has been this massive increase in litigation in the semiconductor industry, which is, as it turns out, consistent with what's been happening across the board in patent litigation. This is from the same PricewaterhouseCoopers study. It shows the number of patent cases filed going from about 1,000 in 1991 to about a little over 5,000 in 2012. I think that 5,000 number is a little high, but whether it's 5,000 or 4,500, I'm not sure it matters hugely. It's a 450% growth over that period. So this phenomenon, the use of these patent rights has grown dramatically. The nature of that litigation has also changed fundamentally. This is from the same study that we were looking at before. It's a sample of semiconductor companies, and you can see that there's an inflection point in this data at about 1994. And roughly, what that's showing is, an increase in, or rather a decrease in the number of suits between competitors. So for the initial period, that's that early period when there were very few cases filed, about 2 a year, about 70% of the cases were between competitors. Between 1983 and 94, almost 90%. When you talk about a sample of 17 cases, the difference between 70 and 90% is not a whole lot. But strikingly, in 95, starting in 95 through 2001, and that's the period when there were the most cases filed, the likelihood that a suit would be a competitor suit dropped to 50%. So the mix of litigation was changing substantially. I'll skip past this. This is sort of a write-up from the General Accounting Office, which actually just last week has published a study on this subject. But again, it's making the same point, that roughly at some time, whether you put it in the 80s or the mid-90s or the late 90s, the mix of litigation changed, and the way in which patent rights were used changed from being predominantly a use that was intended to integrate with competition to something else. And that something else is fondly referred to in my profession as patent trolls, or NPEs. Patent trolls is another one of these terms that is, everybody's got a different definition of. NPE is the polite phrase for this group of people. It stands for non-practicing entities. But very roughly, it's meant to be the category of companies which acquire patent rights and assert them even though they are not competing in the technology associated with the rights. And that type of litigation has grown dramatically. In 2001, there were roughly 600 of these cases filed. By last year, there were about, I'm sorry, I used the wrong number. There were roughly 600 defendants sued in cases of this sort. By last year, there were about 4,200, 4,300, 4,400. The numbers vary a little bit. And so I'm talking here not about the number of cases filed, but the number of defendants who get sued. So 3 defendants might get sued in a case. That would be 3 defendants. In some of these cases, it can be upwards of dozens, or one case I had recently, 150. But basically, the likelihood, the reason I use this number is because it gives you a sense of what the likelihood that a particular company is going to be sued in a matter like this and have to deal with this phenomenon is. And whatever that likelihood is, it's growing. In the last several years, and this varies a little bit depending on whose numbers you look at, the fact is that more than half of the lawsuits that are filed by these NPE entities. This is from a company called RPX, which is in the business of roughly helping companies that tend to get sued develop economic strategies for avoiding that risk. And by their count, for the last several years, the percentage of defendants sued by NPEs, by these non-practicing entities, as a percentage of all patent infringement defendants has climbed over 60%. It's been over 50% since 2010. This is consistent with that trend that we were looking at before in your industry, but it's just simply taking it global. The General Accounting Office, as I said, did a similar study. They don't come up with quite as large a percentage. But again, they show, or quite as dramatic an increase, but they show the percentage of competitor suits overall dropping from about 76% in 2007 to about 59% in 2011. So, whether the NPE suits are 40% or 50% or 60%, I'm not sure it makes a huge difference. What's critical is, or what's significant is, that they are a major piece of what's happening in the courts, and that's, as I said, been increasing. And it's been increasing dramatically in your industry, in the electronics industry in general, and in semiconductors in particular. This is from a study done by a company called ChipWorks in 2011, based, I believe, on 2010 data. Their estimate was that in the semiconductor industry for that year, roughly, looks like about maybe a little over 100 of a little over 300 cases were competitor cases. So if you recall those slides we were looking at earlier, you're going from a world where 70% of the cases are brought by competitors to a world where 70% of the cases are brought by non-competitors. In the electronics industry, it's a little more 50-50. And then this is yet another study. This one is done by RPX, basically identifying the industries which are most frequently sued by these NPEs. And the ones I've highlighted in red are the ones that where semiconductor issues typically are involved. So again, these involve things like computers, consumer electronics, networking, mobile communications, and the semiconductor industry itself. But a significant amount of this is essentially your industry. That tall bar at the far left, that's e-commerce and software industry. And so just as we saw that software patents were one of the major drivers in terms of the overall growth in patenting, they're also one of the major targets of this phenomenon. Well, given that we've had this sort of transition, what does that mean? How has that affected your industries? Well, the first answer is it means, the good news for me is that it means that legal fees are being paid, and a lot of them. Patent litigation is an expensive undertaking. There are a variety of surveys. Everybody comes up with a different number. One survey that's been around for a long time is conducted by the American Intellectual Property Lawyers Association. In 2011, they put the cost at somewhere between $500,000 and $3.6 million through discovery. So that's the close of the factual development phase in a case, and at between about $1 million and $6 million through trial. Another study was done looking at fee awards that are granted in cases. That happens under certain circumstances, and it's at least a publicly available source of data. They came up with a number about $1 million, $850,000 through summary judgment, which typically is something that happens in a case, I don't know, maybe 2/3 or 3/4 of the way through. It's at the end of discovery. It's a way of cutting the case short before trial, to roughly $3.6 million through trial. What the exact number is, nobody really knows, and the distributions are skewed, and there's all kinds of statistical noise, but roughly it's a lot. To try a patent case is a multi-million-dollar project. And then, of course, there's also damages. So you not only get the privilege of paying a law firm when you're sued, you run the risk of losing and being assessed damages. The median number, there are a lot of studies of this number. The most statistically rigorous I've been able to find puts the median at 5 million. But as you can see, it's it's not a smooth distribution. Most of the awards are that bar at the left, which is $0 to $500,000. There are a small number to the right, which is north of $200 million. And obviously the big numbers sort of swamp the little numbers in terms of calculating means. But it's the takeaway from this slide, I think, is that if the cost of simply paying to try the case is a couple of $1 million, the risk associated with the case is also typically going to be a couple of $1 million, and often will be substantially more. This sort of drives that point home. It contrasts the mean and median amounts. The dark bars are the mean amounts. The light bars are the median amounts. And as you can see, in recent years, the means have been in the $55 to $60 million range. But of course, most patent cases don't actually go through to trial. In fact, only about 5% do. These are the figures for the different stages at which patent lawsuits terminate. About 5% go through to trial, so only about 5% result in those damages awards or incur those multi-million-dollar fees. Another 15 or so percent get settled kind of at the very end, following what's called the pretrial conference, but 80% of the cases get settled roughly somewhere in the middle. About 40%, 37% of patent cases last around 6 months. An additional 25 last 7 to 12 months, so roughly a little over half are terminated within the first year, 26% a year to 2 years, and then the rest across the board. The average time to trial in a patent case is about 30 months. So by and large, these cases are resolving about half the time in the first third of their life, or first, 40% of their life, and then decreasing as you go along. So there have been some studies trying to figure out what the actual cost is, what the average costs are. A recent one that was published by some professors at Boston University came up with a mean legal cost of 1.4 million. The number in parentheses is the standard deviation. Median cost of about 200,000. If you look at the settlement amounts, so not the damages figure, because you only get to damages if you get to trial, but what people actually pay to get out of these cases, the numbers varied dramatically. In the cases that were litigated, they were about 6.5 million. Many cases many patent assertion claims are never litigated. They're simply settled without litigation. And those actually tend to be higher numbers. In this study, about 30 million. But again, these numbers are subject to large standard errors. The litigation number, standard error, is about 1.75 million. The settled without litigation number, the standard error, is almost 14 million. The median licensing cost is much lower. It's about $250,000, all of which is telling you that there is a very skewed distribution here. The 95th percentile of cases has a total resolution cost, so that's settlement plus fees, on the order of a little over $19 million. The 75th percentile is 2 million. The median is 600,000, and the mean is about 7.5 million. Those numbers vary across industries. You are fortunate to be in an industry where the numbers are the largest, primarily because the stakes are the largest. The mean resolution cost in the semiconductor industry is $13.7 million for these lawsuits. 9.3 million in hardware, 4.2 million in networking, 3 million in software, and about 900,000 for a website. This, again, is legal fees plus settlement expense. That number, the variability across these numbers is largely driven by the largest cases. So if you pull out the cases that settled or cost in excess of 10 million, the averages are between $1 million and $1.4 million across these industries. This is a reiteration. These numbers affect different companies differently. This is a scattergram of the sort of all the data that we've been looking at for the various companies from which it was compiled. And what's evident is that there are a small number of companies towards the top and the right-hand side of the distribution. The y-axis is the number of NPE cases in 2012. The x-axis is the reported revenues associated with the companies involved in those cases. So roughly, what you see is that the bigger the companies get, the more often they get sued. This is another study that kind of makes the same point. This was done by an outfit called Patent Freedom Foundation, which is a sort of an anti-NPE website. And what I've highlighted are the companies who they get sued on a variety of technologies, but among the technologies that are involved are semiconductor technologies. By and large, they're in the electronics industry. And again, the bigger the company, probably not surprising, the more often it gets sued. This slide simply breaks down the data, the same data in a different way. It roughly shows that even though the largest companies, those with 50 billion in revenue, amount to about 3% of the unique companies that are sued, those companies represent about 12% of the total cases. So they're being represented or sued about 4 times as often as their presence in the population would suggest. And this is another way of looking at the same figures. The $50 billion companies are sued on average about 7.5 times a year. The companies with less than $100 million in sales are sued, if they're sued at all, are sued about once or maybe a little over 1.2 times. And not surprising, the mean cost of resolution varies directly with the company's size. So the bigger the company, the more is typically paid to get rid of these cases. Reiterates the same point. So if you kind of spread those numbers out, what that means is that for the biggest companies, the basic impact on them is that they pay a fairly substantial troll tax, if you will. For the $50 billion companies, if they're sued an average of 7.3 times and they pay an average of $7.9 million to resolve those cases, that's a little less than $60 million a year. 10 to 50 billion, it's about 30 million and on down as the companies diminish in size. That's real money, and that's an important effect, but the most dramatic effect of these lawsuits actually turns out to be on the smaller companies. Of the defendants sued by NPEs, a little over 55%, 55% have revenues of less than 10 million, or 10 million or less. In contrast, of the defendants sued by operating companies, only about 16% had revenues of that level. 60% of the NPE royalty demands involve software or high-tech patents. So roughly this phenomenon, essentially what these numbers tell you is that this phenomenon is hitting most substantially in small high-tech companies. And it has an effect on them. This is from a survey that was done of startups in the tech industry. And the question was whether PAE is an acronym for Patent Assertion Entities, which is essentially a type of NPE. The question was, what's been the consequence of these demands on your company? For the smaller companies, over 60% responded that the demand alone had a significant operational impact. That was 55% for companies between, up to 100,000 was 62%, 55% for 100,000 to a million, 40% for 1 to 10 million, 42% for 10 to 100 million, and after that, basically the operational effect disappears. This is a little more detail on what that means. For the 40% of the surveyed companies where there was one or more significant operational impact, that manifested itself in any number of things: 18% product change, 15% delay in meeting a non-headcount milestone, so something about the development or growth of the company. 13% exited a business line or pivoted in their business strategy. 10% delayed in hiring, 4% experienced a fundraising impact. And it's not hard to figure out why, because if you just kind of add up these numbers and think about them against the types of revenues that we're looking at, they have dramatic effects. So here is this is again from the same survey, and here companies were asked what their response was and what the average cost was, and what that amounted to as a percentage of their annual revenue. How much of their annual revenue was spent resolving the demand. The That last answer ranged from a low of 0% when the company did nothing, which I guess is a strategy, to as much as 24% for the company fighting it in court, 13% for the companies which settled, 13% for the product companies which changed their businesses, and on the order of 5% for trying to resolve things, fighting out of court, whatever that means. Presumably that's the negotiation process. But these are real numbers, especially for small startup companies. In the aggregate, the numbers are large. This is from that Boston University study I was talking about before. Their tabulation puts the total amount of money that's spent on NPE litigation at $29 billion a year as of 2011. This number's been subject to a lot of criticism, and my own belief is that it's high because this is kind of a skewed sample. But whether it's $29 billion or $11 billion, as this next slide would indicate, it's a lot of money. So who are these people and why are they doing these terrible things? Well, most of them are, 90% of them, are non-operating entities whose only business is asserting patents. Individual inventors make up about 7%. An operating entity that's not competing in the field of the patent is 2%. Universities are 1%. This slide is a little misleading because a lot of the companies in that 90% are in fact, as we'll see later, they're in fact vehicles for companies in the other bars. So sort of an increasing phenomenon is for operating companies to transfer their intellectual property rights to non-operating companies and let them assert the patents. I'm pressing my time, so I have to speed up. The reason why they're doing this is very simple. It's a good way to make money. The business model has attracted literally billions of dollars of investment capital. This is a list of the market capitalization of publicly traded entities that either are exclusively in the NPE business or substantially in it. There are probably people on this list who would object to their inclusion, and maybe they're right. But I actually took this from a blog. It's put up by a magazine, a publication called Intellectual Asset Management. If it's not a perfect list, it at least is indicative of companies, a substantial portion of whose business model is this type of litigation. And they are attracting substantial investment capital. As I said, it's a project, a program that is being adopted by whatever the opposite of an NPE is, competitors. So there's an outfit called Round Rock Research, which is in the business of suing people on patents. They hold a portfolio of 4,200 patents from Micron Technologies. There's an outfit called Suffolk Technologies, which has a relationship with British Telecom. Nokia and Microsoft have aligned themselves with a company called Mosaid, which actually has its own research organization, I think thinks of itself as an innovation company. But much of their business model is based on generating revenues out of the patent rights that they acquire. And then they go on, Nokia, Ericsson, Renesas. There's the Rockstar Consortium, which is the group that bought the patents owned by Nortel, which are now in the process of being licensed to a variety of people. Harris, the semiconductor company, and the list could be expanded. 12 publicly traded NPEs reported almost $6 billion in revenue between 2005 and 2011. Again, what counts as an NPE is, subject to dispute and how much their revenue is. So maybe it's not 12, maybe it's 10, maybe it's not 6 billion, maybe it's 4, I don't know. But it's, again, real money. It's a good way to make money because the odds are stacked in your favor. The likelihood of prevailing isn't in your favor. Actually, the likelihood of prevailing favors the defendant, because in order to get a verdict and hold on to it, you have to survive what's called a summary judgment motion, which is a sort of a gating process that determines whether you're going to go to trial or not. You have to win a trial, and then you have to win on appeal. The likelihood of each of those events is in the neighborhood of 60%, but you have to flip the coin 3 times and get heads each time. So the cumulative likelihood is about 24%. But if you use that number and kind of apply it against, and I apologize, I'm going to speed up here because I'm taking up too much of your time, and apply it against some of the numbers we've looked at in terms of the damages risk and the cost of litigation, roughly what you'll see is that for the average defendant, in significant part because of the litigation cost, there's an exposure, a net discounted value of almost $4 million to the average patent suit, which of course doesn't exist, but a significant amount of money, even though the likelihood of losing that suit in the end is relatively small. And from the perspective of the plaintiff, actually the value isn't all that high. But when you put those together, what you've got is a bargaining range between the two when they're sitting down to talk about settlement, that A is positive and B is in the millions of dollars, even though the likelihood of the defendant prevailing is relatively good. That's a good business to be in. And that's why a lot of people are in it. So what's likely to happen? How long a trend are we looking at? We've seen this kind of explosion of this phenomenon. Is that the way that the cases are likely to continue trending, or is there likely to be a little bit of correction? What I'm going to suggest is that there are a number of things that are sort of, as with most bubbles, trending to ameliorate this one. If you do that arithmetic that we were just looking at, those numbers are driven by 2 things: the cost of litigation and the risk of litigation. On the cost side, the numbers are actually going down. These trend lines, the bottom, the purple one is the number of cases filed. I don't know what that color is, pinky orange one is the number of defendants sued, and the yellowish one is the number of attorneys. And this is on a percent change basis. And what you can see is that since 2000, the peak of, I guess, about 2006 or 7, the number of attorneys has dropped dramatically relative to the number of defendants sued and the number of cases filed. This is no secret, which I can't imagine why you would be if you read the legal trade press. The legal industry has been under a very substantial cost pressure, pricing pressure for the last several years, and that's manifested, itself, in this type of litigation. Another thing that is likely to affect the fee side of this equation is legislation. Congress is perpetually reforming the patent system. And NPEs are the current fad. Obama has talked about them. NPR has had reports on them, which for the patent litigation industry is sort of a pretty high media profile. And there's been a lot of congressional activity. The current focus is on fee-shifting legislation, which is roughly intended to make it more likely that the prevailing party in a lawsuit will be able to recover its attorney's fees. And again, if you look back at these calculations, if you make that litigation cost 0 for a prevailing defendant, then that bargaining range shrinks dramatically and changes substantially. Another thing that's happening is people are finding other things to do with intellectual property than litigate them. RPX is what's called this company I was referring to earlier is what's called a patent aggregation company. What they're doing is they basically charge an annual subscription fee to their membership, their members, which are roughly the people who get sued in these cases. And they use that money to acquire patents which they believe are likely to be asserted or which have been asserted. So it's a little bit like an insurance scheme. It basically is that they're basically out there soaking up the exposure to their membership companies. Some companies have started selling covenants not to sue in an auction setting. So basically, instead of bothering with the whole process of litigation, they just cut right to the chase. They say, here are the patent rights we have. You're entitled to bid on the right for us not to assert those rights. There was an auction of that sort in March of 2011. It was kind of a mixed success, but at least one lot of covenants not to sue was successfully sold for, where was it? $35 million. And there were bids on other lots as high as $75 million. This was another auction of the same sort, smaller numbers. The reserves for the patents, for the patent rights were in the $5 to $10 million range. People bid 3 to 7. I don't think any of those cleared either. There's a company called the Intellectual Property Exchange International, IPXI, which has been launched. Their first contract is being traded. It's issued by Philips, so a real player. And the concept is that people will be able to buy patent licenses, essentially, in an exchange setting. So they will buy the amount of protection that they need in that context with very little transaction cost. Major players are involved in that. I'm just going to go through these slides really quickly because I'm past my limit. A couple of other things. The Patent and Trademark Office has become an alternative to litigation in important ways. That was fostered by the recent Patent Reform Act, the most recent Patent Reform Act that actually passed. They have a procedure for adjudicating the validity of patents that's much faster and cheaper than district court litigation. The risks associated with patent litigation are diminishing. It's much harder today to get an injunction than it was 5 years ago. I think it's about 5 years, which of course is the biggest threat to a patent. So these NPEs really are having a very difficult time getting that kind of relief. The risk of large damage awards, probably the incidence is still relatively high because the absolute size of these awards is driven by the amount of business that's at issue. But the rules for measuring damages are getting much stricter. And as a consequence, the size of those boxcar awards, I think, is going to diminish. Thank you for your patience and your attention, and I'm happy to answer any questions. Yes, sir.
Okay, Hal Kellman, HRK Enterprises. I really enjoyed your presentation. I'd like you to elaborate on your next to the last slide because I talked to a lot of Silicon Valley executives and they seem to think, yeah, there it is. They seem to think that ITC 337 is like a holy grail or a silver bullet because it's a specialized court in Washington, D.C. There's no jury, and there's a fixed amount of time. And up until a month ago, they said no decision had been overturned since 1987. So, of course, within the last 30 days, Barack Obama was the first president to do it. So you seem to be saying that even before this, the ITC is not a great way to go, but the executives thought so, at least the ones I talked to. Could you elaborate on that?
Sure. So the ITC is an agency in Washington. It regulates it's a way of adjudicating import-export abuses. So it addresses things like unfair competition between countries and anti-dumping sorts of issues. But they also have jurisdiction over patent infringement. So when a product is imported into the U.S. that infringes the intellectual property rights of a U.S. industry, the ITC can hear that action and can ban that product from being imported to the U.S. The ITC is very attractive in some ways. It's very fast. The ITC rulings are subject to being voided by the president, but also subject to appeal to the Federal Circuit Court of Appeals. I think what you were referring to is presidential decisions, and President Obama issued the first of those just recently. Right. It was the first time in a long time. The Federal Circuit has a little heavier thumb, and they tend to overturn these things on a decent basis. The problems with the ITC, first, it's hugely expensive. It's a typical ITC proceeding is 2, 3, 4 times the numbers that we were looking at. Second, the ITC actually is not that favorable a forum to plaintiffs. So the win rates at trial in a district court are on the order of 65 to 70%. At trial before the ITC, it's hard to say, but it's more like 40 to 50%. Third, it's just not, there aren't that many cases there. The ITC at its peak was hearing about 70 cases a year. That was about 2 years ago. This year it's on a pace to hear about 35, and that's traditionally where it's been. And you contrast that with, depending on how you count, 3, 4, 5,000 a year that are filed in district court. There also has to be a domestic industry to protect. Whether NPEs meet that requirement is an increasingly unclear matter, and there's a lot of pressure on the ITC to not extend the availability of the commission to them. What I think is going to evolve as another option is the European Union, because they are in the process of implementing what they call a unified patent court, which will be a single court that covers the entire EU jurisdiction. So it will cover a market that's actually larger than the US. European patent litigation is usually a fraction of US patent litigation. It's much quicker, and the availability of an injunction is much higher. So if I were sort of betting on litigation futures, my money would be on the EU rather than the ITC. Yes, sir.
My name is Naresh Patra. I have been associated in the past with Texas Instruments, which is well known for some of the multi-billion-dollar lawsuits that they filed against the Japanese and collected a lot of royalty. But my question really, 2 things that you did not touch is copyright and trade secrets. In the copyright, again, I was associated with a company, especially in the semiconductor industry, the mask sets can be copyrighted, and in the past, companies have reverse engineered chips by layer stripping and taking photographs. And I was associated with a company, and the landmark case of Brooktree versus, I will not name the other company. So, and again, I'd like to also know some trade secrets. In the patent, you end up disclosing most of the recipes and circuits, whereas in trade secrets, over the centuries, certain companies have kept the trade secret and are not disclosing them. So that's another way of protecting and avoiding the litigation. It would be nice if you touch a little bit on that, especially Coke is well known for its trade secrets and formula, and chemical companies do that all the time.
Sure. Well, I mean, Coca-Cola is the most famous trade secret in the world. Nobody knows the formula. Copyright and trade secret are alternative ways of protecting the intellectual property rights associated with, in this case, semiconductors. Copyright and trade secret litigation, I don't have the numbers with me, but have not seen the kind of explosive growth that you've seen in the patent area, and they have not attracted this kind of strange NPE type participant. I think in large part because those property rights are much harder to pull apart from the actual production and marketing of a product. But there's a significant amount of law and litigation in that area. Some people, Judge Posner in Chicago believes that the only reason we have a patent system is because trade secrets are an imperfect device for protecting rights, because it's hard to assure secrecy over an extended period of time. And there are many people who think that that's sort of the right way to protect these rights. But I think it's a viable alternative for a company that wants to protect its rights. But from the perspective of what I've been talking about today, I think those mechanisms have the virtue of somehow being tied more directly to competition. So they seem to be rooted more firmly in the kinds of economic justifications that exist for those types of rights. I hope that's helpful. Yes, sir.
Hi, Donald Forbes, Biscuit Tech, over from Cambridge in the UK. I'm writing patents at the moment, so it's a live issue. The things I would bid for is clarity in the language. I see patents, several, that are so vague as to be unenforceable. And you didn't address the business of clarity and interpretation in your talk, but it's not a criticism when you come to it.
That's a really good point, and there's actually some academic literature that argues that it's precisely the fuzziness of the patent boundary that has created the amount of litigation that we've seen. And it's obviously a distinction between the real estate analogy that I used at the outset, because you can say, there's the property line, you know, and that's it. I think there are two answers to that. The first is, yes, there are some horrible patents out there. And typically what happens at the Patent Office is that as the technology emerges, some really lousy patents get issued because the examiners are essentially learning how to evaluate the applications that they see. And so what you typically see is at the start of an industry's growth, you see a lot of bad patents with badly written claims and probably not very well supported specifications being issued. Over time, I think the PTO tends to do a much better job. And in fact, there's been a major investment of energy in improving patent quality in the last couple of years. And depending who you talk to, I think that's had some success. The second answer, though, I think, is that vagueness is often in the eye of the beholder. And language is, I mean, I make my living dealing with language. There wouldn't be a legal profession if there wasn't vagueness in the English language. There would be nothing to fight about. And I think what happens is that the more intellectual pressure you put on the language in a patent or a statute or a constitution, the more you find vagueness and the more uncertainty emerges in evaluating a particular issue. So I think your observation has some very real empirical basis. And as I said, there's some interesting academic literature discussing that. I think as a long-term issue, it's more a reflection of how significant these things have become and how much energy gets put into finding vagueness.
Okay. David Fish with Tessera. Mm-hmm. Regarding this last slide and the notion that patent trolls or NPEs or inventors perhaps who don't build a product, that their leverage and value of their patent depends now to some degree on who owns the patent. I'd like to hear would you agree with that to some degree the value of patent now depends on whether you're building a product or not, and what's your take on that?
Well, the answer to the first question is probably yes, because it's simply easier to get an injunction if you own the patent. An injunction is a court order that requires somebody to do something, in this case, stop using the infringed technology. And it's the most powerful remedy that's available because it can essentially put a company out of a business or at least out of a product line. The way the law has evolved in the last couple of years, it's very difficult for a company that is not a competitor to get that kind of relief. As a consequence, I think it's fair to say that patents are more valuable, at least in that respect, in the hands of a competitor. Now, the flip side to that is that competitors are actually in competition, and they make products, and if they sue somebody on a patent, they have products that are vulnerable to the other guy's patents. So when they come into a patent lawsuit, they do so accepting a certain risk to their own business line. An NPE has the advantage of not being in that situation because there's really not much of a counterclaim that you can make. So how those things wash out in terms of the ultimate value of the patent, I'm not smart enough to know. But I think they both weigh in the scales. Thank you so much. I really appreciate the opportunity.